contrary to the statute, then enforcement of fundamental rights. The orders against which no appeal is provided are essentially, one is commissioner of where you can file writ petitions. One is commissioner's powers, orders in revision. The other is when an appeal is filed to the commissioner appeals from an assistant commissioner's order, there is no power of stay in the commissioner appeals. So you apply to the assessing officer that you stay the demand till my appeal is disposed of. And against that you go to the jurisdictional commissioner. But at times they don't grant a stay. Then that is the time when people move the High Court and saying that there are decisions in my favor and he ought to have granted stay. That is the second class of categories of cases. Then there are orders of the Central Board of Direct Taxes. Now, Central Board of Direct Taxes which is issued by the Central Board, stating that you can the time limit is extended. It is again specific to the particular SSC. So I guess those orders also people do challenge. And then challenge is also when the Central Board has also the power to transfer the assessment from one assessing officer to another assessing officer. Now that, if it is not correct, that is also another area where the court challenges, or where the SSCs do challenge. The another area, largely the area is of reopening of assessments under section 147 and 148. But like in any normal writ petition, what has to be shown is effective alternative remedy is not available. There are no disputed questions of fact. It is not an academic question. It's a finding of fact which is perverse. It is a policy decision. It's not a policy decision, not prohibited by statute, and there has been no delay in moving the court. And lastly, that my conduct has been such, that the conduct of the person approaching the court has been such that it is clean, that it is not subject, that the income escape assessment. Now the statute itself did not provide, but there was a Supreme Court case called GK and Drive Shafts, which set out the procedure to be followed. Once in the old system, I am referring to the old system only to show the contradiction, which I will refer to in the new system. In that system, under that procedure, once a reopening notice is called, the SSC is asked to file his return of income. The SSC can call for the assessing officer before issuing a notice and to record his reasons why he believes or why he has reason to believe that income escape assessment. Now that could be a subject matter of challenge before the assessing officer and saying that you have no reason to believe. That could be accepted, rejected, and then that could be a subject matter of, if you don't accept his rejection, it could be a subject matter of what we feel. Reason to believe has been done away with, which suggests that issue a notice to the party. That would be responsible. Why? They have defined what would be called information. Even an audit which has been taken place and as a consequence of audit, some queries have been raised. That could be an information on which a notice could be issued. Earlier, the writs were filed that there was no, the assessing officer could have no reason to believe because the entire exercise was done earlier and it doesn't give him the facts on which he is basing his claim will not lead to any reason to believe that income has escaped assessment. So therefore, the challenge now is only very limited and it can only be that this is a change of opinion. Earlier, you could always contest change of opinion by saying that under 143 complete scrutiny assessment was done. And therefore, if it was beyond, you couldn't do it beyond 4 years. Now, there is no distinction to reopen between 143 and 141 are done away with. However, the point is that it could still be challenged on the ground that he has already applied his mind. Really, with a change of an officer who comes in and sees and he has a different view, then it would not give jurisdiction to reopen an assessment. Of course, these provisions are still very nascent, new provisions, and court-made laws will develop over a period of time. I think that's all I have to say. And thank you for a very patient hearing.
Have an interactive session. For that, I call Advocate Amira Razak, Standing Counsel Income Tax, Official Regulator, and Government Advocate to conduct this interactive session. It's a pleasure to have you here. Sir's encapsulation of the Income Tax Act into 45 minutes reveals his brilliance and his mastery of the subject. May we have questions from the audience? Either you've understood everything or nothing at all. On behalf of my colleagues at the bar, may I request, please could you elaborate on tax avoidance, tax evasion, and guard provisions?
Would it be nice provision in the Act? Once the Vodafone decision of the courts are really aimed at what I'm open to an assessing officer in that light to try and recover the balance amount. That is one, 15% and 20%. Two is, though the statute does not provide for an appeal to the Commissioner Appeals, or a stay application to the Commissioner Appeals, yet there is a decision of the Supreme Court in Mohammed Punni's case, where they said that every appellate authority has an inherent right to stay the orders of the subordinate authorities, because it is in interest of the final order which is going to pass. So one could certainly do that. But to answer your specific question, is that the assessing officer cannot do that. And if he still insists and issues letters, then there is a proper forum to go and see that he stops issuing. Yes.
And there are many guidelines which are laid down by the High Court, Bombay High Court in the case of KEC International. They have said how to deal with the stay application. Oftentimes, assessing officers, CITs, they reject it personally without showing that they have to be high pitched the parameters within which stay applications have to be laid down certain percentages which are granted. So, any other questions?
So 21 it is amended, though it is not bodily engrafted in 148A. What would be your view? The scope for interference is wider or narrower now after 1st April 2021 for the High Court in the
material which he has. And the second one is a change of opinion. The change of opinion still remains. The reason to believe is, so one could still argue that the information should suggest income escaping assessment. And therefore, there is the information which is gone would not even remotely suggest that any income is escaped assessment. But reason to believe is certainly on a higher pedestal than
perhaps non-consideration of the reply to the show cause.
Yes.
Thank you.
And that cannot be taken as a mini trial before the stage of 148A, cannot be treated as a mini trial before the stage of 148. And there is an exception which is built into it, where a notice for reopening can be directly sent to an assessee, even if the provision of 148A exists. And there are certain exceptions which are carved out in 148 itself, 148A itself. Yes, please.
I'm Pranam Naik, Chartered Accountant. When an assessment order is framed by an assessing officer, the course of action available to an assessee is
that the assessing officers don't make money on the side. They don't discriminate between different assessees. But that does not work on the ground. I mean, so therefore the cure is worse than the disease. I mean,
eventually the appeals will grow.
Correct, appeals will grow. Absolutely. Absolutely.
Any further questions?
Condonation petition. So, is it condonation petition acceptance or rejection? Is there any high court guidelines, etc.?
It cannot be a universal, to my knowledge. I mean, are there any reasons on what? Because it will depend from case to case basis. It cannot be. It will depend on case to case basis and what cause has been made out for condonation of it. There cannot be a universal cause. Then they would have provided for extended time itself.
Thank you.
Thank you, sir. Thank you, madam. We acknowledge the presence of Honorable Justice Madam Nivedita. I request Advocate Manaswi Shirokar to present the token to our Honorable Justice Nivedita Madam.
Good morning, friends. I take this opportunity, first of all, to thank the people of Goa for shaping my career. And I attribute today, whatever I am, to a great extent. In fact, my first brief I got by default because Justice Sonak was elevated and Entertainment Society of Goa couldn't find anybody to take risk with. So they had to take a risk with me, and that is how the Goa journey started. And thereafter it was never looking back, and especially the chartered accountants and lawyers of Goa who gave me so much love. I never felt that I was an outsider. And your president of the Bar Association, whenever I used to come to Goa, he used to tease me by saying that I'm son-in-law of Goa. Now coming to today's topic as to how to work on the tax matter, commercial transactions or the factory to see how they are doing the business. So whenever you are representing a tax matter, it is very relevant for you to, because he's from that other parts of the country, the chances of his understanding such a complex transaction is very less. But has PT or the thesis on the transaction, because then it is easy for that person to read and understand. The reason again why you have to put in black and white. So if you have put your case or the facts, all facts at the assessment stage itself, that is so far as direct tax is concerned. So naturally we just write 3 lines, the officer erred in doing so and so. But when it comes to the High Court, judges will ask you, where have you taken this ground? So now you are in a catch-20 situation. The rule provides that the ground should be brief, and the High Court judge is asking you, where is this particular ground? So to overcome that, what you should do is that in your written submissions, you have to raise in your submissions all particular arguments which you think is necessary. So at least from the submissions, you can tell the court that this is the point which was raised before the authorities. So your submissions have to be very detailed. Examine that particular section, then this would have not been possible. Many times, same phrase is used in different sections of the act. So unless you know those other sections where this phrase is used, you will not be in a position to lay down the or help matter when I was practicing. There is a section 140 capital A which says that when you file your return, you have to pay your self-assessment tax. So prior to 89, there was section 140A and I think subsection 5, where penalty was provided if you do not pay the self-assessment tax along with the return of income. That section remained as it is. Then 89, the scheme was changed and we got section 234A, delay in filing the return, 234B, if there is a deferment or default in 90% of the tax, advance tax payment, 234C, where you have not complied with the quarterly mandate of payment of advance tax. Even after 234 ABC, when we studied that matter and we found this particular 234 ABC having introduced from 1989, because prior to that, that 234 ABC interest deferment and all was not there. So we took the view, yes, after 1989 you cannot levy penalty on. So this could have been possible only because we studied the interplay of the section. Otherwise, it would have not been possible. So it's not only that particular section. You have to relate it with some other sections. Similarly, the example which I gave of 144C, 144C subsection 13 provides that within 1 month the officer has to give effect to the DRP's direction and pass the assessment order. And it says notwithstanding anything contained in section 153. The general limitation for passing the order is under 153. Or is it a directory provision? Now, because the phrase used was notwithstanding anything contained, and we realize what was overridden is the time limit given in 153, but not the nature of the limitation which is engrafted in 153. So, it is a mandatory provision on the case laws. Even if the Supreme Court is in your favor or against you, don't go to the court or to the tribunal on the premise that now it is an open and shut case. You study that particular, if it is against you or favor, whatever it is, you study even the Supreme Court judgment minutely and see whether it could be made applicable to the facts of your case. Prima facie, you may feel it is in your favor or it is against you. The reason why I am saying is the classic example is of section 11 of the Arbitration Act, appointment of arbitrator. But even that section traveled from 2 judge to 3 judge, 5 judge, 7 judge, or not a correct law, or is it applicable to your case or not to your case. So even if you feel the Supreme Court may not be correct, the law has to be developed and it has to be progressive. It has to keep itself updated with the current scenario. So even if there are judgments in your favor or against you, don't go on the premise that it is an open and shut case. You study well whether it applies or it gives you the basic important dates and events and the propositions. It should not be long, but at least 1.5, 2 pages. So that becomes it becomes very difficult for us, and then the sufferers will be either one of the parties. Whenever any questions are asked, we have seen the tendency is to deflate that question and go to the other point. But my personal advice to all of you that I understand. I can stand and. No, sir. I'll ask Vinesh quickly and thus. Vinesh, where is he?
Thank you, sir. You have beautifully explained in a simple manner the procedure. Mr. Vinay.
For us, grappling with preparing these appeals or even briefing the council is a matter of challenge. The very lucid, simplified manner in which we have taken it sectionally for us to be able to digest this, I think every practitioner will be, I think, lifelong obliged to you. I would request a loud round of applause, please. I've had the good fortune and honor of briefing sir on a couple of matters, and I know what he has preached here, he practices to the T. So, before, I have a few questions of my own.
Welcome, sir, to Goa. My question here is, we are facing one practical Indian national. There is no issue. We deduct 1% TDS. But when we are doing a sale deal with respect to a person holding a overseas citizen of India card, then there is a different slab provided for deduction of TDS. Holding an OCI card, but who is residing in India and is asked to individuals who are overseas citizens of India. So my question is, how do we resolve this issue? Because I just complete myself. One of the suggestions given by the sub-registrars is that we should obtain a tax residence certificate from the ITO. Now, this is practically sometimes very, very difficult. So I would just request if your lordships could grant.
You don't have to pay anything from your pocket. You have to deduct from whatever 100 rupees you are going to give. And you have to protect yourself, because if there is a short deduction or no deduction, the consequences of penalty, prosecution is on you. So you would be in a position where without such case, the conservative approach, so far as the person paying is concerned, the seller is concerned, is to deduct at a higher rate. There's a practical thing. In getting the transaction go through, then I would advise that you have to take an undertaking that higher rate is required to be deducted, and you still deduct from the lower rate, then I don't think the tax department will not be justified in taking action against you. But if a normal person would have taken, so at least that can help you in facing the consequences of the tax authority. That is what I feel would be the better approach.
Just one more question I'll add to this. How far is the grant of a tax residence certificate justified for the production before the some though I'm holding a taxes and deduction of tax at a lower slab, which is as applicable for resident Indians, would be justified. I only want to know what is the justification for grant of this particular tax certificate.
See, the TRC certificate is given by the country, foreign country. So that is a sufficient precaution so far as you are concerned, because that is a certificate, and that is exactly, of course, the controversy in Azadi Bachao Andolan was a TRC certificate of a Mauritius tax authorities, but same ratio would apply. If that, but if you are a seller, I would always, or if you are a buyer, then I would always say that take a conservative approach. Because once the transaction is over, the other party will never cooperate. So it means you who will, the purchaser who is failed to deduct TDS has to face the consequences. So indemnity you can take it, but then again enforcement.
Center has got a right to, they can centralize your taxation. Now, how far the discretion of the revenue to centralize these taxes and the challenge before the High Court by way of a writ.
Exactly you mean by centralization?
Centralization, in one of my matter, what was happening was the SSC, although was here in Goa, which you call the circle for circle is what is considered for Goa, I think. But there was an order which was passed centralizing his taxes to New Delhi.
No. That is centralization of cases.
Yes.
So what happens?
So I try and approach from that perspective and speak to all of you as practitioners. I'm very happy to see that the Bar Association and the ICA have come together, because both tax and securities, by legislation, the practitioners include law do in some facets which lawyers are prone to do, fall in this intermixture when it comes to practicing in this area. So I want to begin with a fundamental theme. that contrary to popular belief that we are a sovereign socialist secular democratic republic, but our constitution actually captures the power of markets. And I'll make this good at the rest of the market. But you sold shares. So that would not be insider trading. And it took a litigation in the Abhijit Rajan versus SEBI case all the way to go to the Supreme Court. Despite concurrent findings, the regulator would keep saying, no, you are in possession and you traded. My regulation says this, so you are in violation. Leaving aside whether the information itself was price sensitive or not, it was found that the information was not price sensitive, but even if it was price sensitive, the character was positive information and not adverse information. And what you did when in possession of it was a sale and not a purchase, and therefore you not law. Another example I want to touch upon is there was a little bit of discussion about BAR, about anti-avoidance regulations. The securities regulatory framework always had an anti-avoidance rule. The section 12A of the SEBI Act, in fact, says no any contrivance or a device. Therefore, when you structure transactions to try and overcome what you market trading rather, because the Supreme Court it was SEBI that was in appeal. Many of you are chartered accountants, and all of you know what happens towards the end of the year, come March. You want to see how do you adjust your accumulated losses or your profits, how do you adjust your losses on securities and gains on securities. So party A executes a put option with party B, or trades in an option with party B. Let me not complicate it by put and call. You trade with the index being valued at say 100 at 12 p.m. at 12 noon. At 12:10, the same two parties do an opposite trade at 50 at the index value of 50. So one party suffers a loss from this arrangement, another party gets a profit from this arrangement, and you adjust value outside. And this is often done for said no, you are actually carrying out an unfair trade practice. It's an unfair trade. When you trade in the index first at 100 and then 10. And this is again an example that I thought I'll give, and I'll come to the structure of the laws in a minute. Then I think I'll spend a little bit of time on the SEBI Act and how it came about and Act of Parliament in 92. But the broad construct of the Act is to create a regulator which should be a licensing authority for a range of service providers, merchant bankers, brokers, sub-brokers, mutual funds, etc. They get a license. Your ICAI for a CA is SEBI for these professionals. But there are facets of the market which doesn't simple principles. Now the FUPP regulations define fraud in its own way. Now look, if you just look at the definition of fraud, fraud as defined in the Contract Act has one structure. Fraud defined in company law, if you look at 447, to conduct, but say 2 years later, on a material particular, that law is amended. There's no consultation, there is no public stakeholder consultation involved. So is that something that we are happy with as a republic? Is again a question to ask. I mean, if you, the regulator, they are very much like any law-making body which will not have an opposition to ask a question, and that can lead to laws being made which do not meet the actual problem that has to be solved. When I say show me a problem, I'll write you a law. Painful than the ailment. And there's again jurisprudence on this. You remember the call drop case, the telecom regulator felt that if you penalize the telecom service provider under the 1992 regulations, in the 2015 regulations, we said that the following types of information would ordinarily be price sensitive. So take for example dividend. Declaration of dividend will be price sensitive. But say a company has declared dividend at 5% for the last 20 years, and it yet again declares dividend at 5%. The market expects it to declare only 5% dividend. So just because it's dividend, and the board was meeting about dividend at the same rate of 5%, that insider would not be in possession of right. It's enough to infer that he told the person on the other side what was to be discussed in the board meeting. So circumstantial evidence is often mistaken and mixed up with beyond reasonable
So, what do you think is a threat, as you said, from the advent of technology and maybe AI or algorithmic trading, things like that? And how do an individual protect himself if he relies on technology to trade in shares?
it's a little more complicated, it's a wider area. Maybe you should have talk on technology and the impact on legal systems. But generally, if you again simplify this, the ability of technology to reach the human mind in ways deeper than legal to envisage is writ large. Eminently, people of greatest integrity, but who are insecure about losing the perception of their integrity, succumb to digital arrest calls. People have nothing to hide. If they are told consistently once their attention is gathered that your reputation will be smithereens, they are willing to get out of it by paying some money, despite having nothing to hide. So the technology is website you're surfing and you post forward on a WhatsApp group enables entry into your mind. That we have to retrain ourselves. We have to reorient how we are, what we buy, theories we buy, imaginary problems we buy into. This digital arrest is an imaginary problem. Hate is an imaginary problem. So this is something that if somebody tells you this stock is going to go up, it's going to have a great value.
Let us say a program suggests me that
So let's take algo trading. Suppose you program an algorithm to put in a trade in the example I gave at 100 and at 50 within seconds of each other and confuse the market. Frankly, in the example I gave, it won't fit because in the example I gave, people are putting in that trade only because they knew there's a counterpart. So the program were to blindly throw up a purchase order at a price that's a huge premium to the market. The rest of the market will react to it and will end up buying from a real counterparty at an inflated price with no assurance of reversing it. So in the example I gave, technology won't fit, but you could program algorithms which should play in this space and it need not be such a wide range. An algorithm may say I'm a buyer at X and seller at X plus zero point 0.5. Question really is that illegitimate or is it not illegitimate? You have to rely on the price bands in the market. It could fall foul of an unfair trade practice. A tax practitioner may say the law allows plus 5 minus 5. So long as my program says plus 5 minus 5, you can't find fault with me. A certain judge may agree with that view. A certain judge may not agree with that view, saying those are bands, those are guardrails. They are not licenses to.
for privacy and privacy protection laws, or are we too late?
There is a huge debate going on privacy protection, data protection law. The chairman of the committee who wrote that law has disowned the current form of the law that it's come out in. There's a huge debate. Is it a protection law? Is it a licensing law? State having access. These are all in the realm of the legislature. It's for society to engage with legislature. It's for society which feels strongly about it to speak up, speak to your respective MLAs, influence the law, and MPs, influence the law. So this is not something I should comment on in my current position.
Sir, if I may ask one question, is considering the, I would not, as your lordship said, I wanted to ask about the current request by SEBI to the government asking for more interventionary powers to intercept messages, but I would not ask that question here. But the other question I wanted to ask was this, is created, the FUDP regulations, are they devoid of taking into consideration behavioral economics? And I will take the reference is, right, say 25 years ago, your lordship appeared in the Samir Arora case, to today, Rajan's case, where if Rajan literally followed the regulations, he would have actually made a profit.
Indian steel that whenever a wrong occurs, there is a lacuna in the law. And that is where this principle comes, show me a problem or right or wrong. We feel law, we can legislate virtue. So we are a over-regulated and under-enforced republic, generally speaking, generally, I mean this totally generally, not with reference to any particular branch of law. Because state capacity is finite. Human ingenuity is infinite. So if you just write more laws, you are burdening state capacity to implement those laws. Like take a, when a Nirbhaya happens, we amend criminal laws and we make it so much more draconian and stringent. And then Shakti Mills happens 2 years later, and then RG Car happens. So we have to ask ourselves, is just asking for more laws, more powers, more stringency, punishment going to achieve virtue? That's a question, that's a wider question we need to ask. And regulators seeking more powers is a symptom of that. Regulators or stock market scam, you take the 91 or the 2001, no regulator would like to say, my system failed. What they would say is, my system failed because. So give me more powers. Heal me. There have been attempts to say that if a person makes profit beyond a certain threshold, we will deem it to be by laws which are in some sense a contract between the members of the platform and the platform. It will be governed by the provisions of contract contained in that bylaws. There is a larger question: what is crypto security? There was a larger question many years ago: is a plantation scheme a security? And very often, when you see the history of regulation making, regulators will initially say, this is not a product regulated by me because I don't want to be responsible for it. So, in plantation, this is not a product of a mutual fund, therefore not mine. It is not a deposit in a bank, the RBI will say it's not mine. It's not an NBFC, not mine. And this is how the product develops. And sometimes it could lead to a serious economic cost and a crisis. But from crisis emerge newer ideas and newer structures. Crypto is currently in that space. Question again is illegal income can also be taxed. Income is what
Advocate Sheena Desai, Secretary, Goa High Court Bar Association, to present the memento to the Honorable Sri Justice Somsekhar Sundaresan, Judge, High Court of Bombay. I request Advocate Maria Simon Korea to present the token to the member of the Goa High Court Bar Association to present the token to the Honorable Miss Justice Judge Nivedita Mehta, High Court of Bombay, Goa. I request Advocate Prashila Arulkar to present the token to the President CA, Mr. Milind Shirodkar. I request Advocate Datta Prasad Lavande to present the token to the Honorable Justice M.S. Sanklecha. Thank you. Gratitude is a sign of noble souls. I request Advocate Shivan Desai to propose the vote of thanks.
Good afternoon, everyone. It can be quite challenging to deliver vote of thanks because normally it stands between bringing down curtains on a function and a lunch, and people who are otherwise in rapt attention, they start wiggling on their chairs. But it is an important task all the same.